Today we are going to discuss the nature of personal property and bailments. Property is often classified based on its movability. So in turn, if the property is movable, then it is considered personal property. Things such as clothes, food, cell phones, concert tickets, or even boats are considered personal property. There are two different types of personal property. The first being tangible personal property, and the second being intangible personal property. So tangible personal property can be seen, touched, and possessed. Tangible personal property includes things such as electronics, animals, jewelry, merchandise, and other similar items such as those things. Intangible property is personal property that consists of evidence of ownership of rights or value. This type of personal property can't be touched or seen itself. Things such as checks, patents, copyrights, and life insurance contracts are all intangible personal property. There are 7 different ways to acquire personal property. One being purchase, which in that case, the buyer pays the seller and in turn, the seller transmits the property to the buyer. Personal property can also be transmitted through a will, but the title does not transfer until the person who made that will dies and an appropriate judicial proceeding has taken place. Personal property can also be acquired through descent. When a person dies without a will, then the heirs acquire the title to the personal property according to the state the descendant lived in. Personal property can be acquired through gift. The donor who is giving the gift must have the intention to make it, and there also has to be a delivery of the property given to the donee. Materials that are owned by 2 people that are combined to form one product is known as a cession. But the person who owned the majority of the property is the one who acquires that property. When the mixing of personal property of different owners occurs, it is known as confusion. If the confusion is caused by common consent or accident, then each party will be deemed the owner of a proportionate part of the mass. If the confusion was willful, then the title of the total mass will be passed to the innocent party unless the confusion can be proven. The last way you can acquire personal property is through creation. The law gives the creator a title for a period of time through patents and copyrights. It can also be protected through a trademark. Now, a bailment is the transfer of possession, but not the title, of personal property by one party, which is usually the owner, to another party. As funeral directors, there are different bailments in our line of work. The biggest one being when a family uses our funeral home for their loved one's services. And we provide those services, but we are also getting paid from the merchandise they purchase or from the use of our transportations and services. That would be considered a mutual benefit bailment. There are 3 different types of bailments. Those include bailments for the sole benefit of the bailor, where the owner of the personal property benefits. Bailments for the sole benefit of the bailee, where the bailee uses another person's personal property and the owner does not benefit in any way, then only the bailee benefits. When both bailor and bailee benefit, this is called a mutual benefit bailment. When a family chooses to buy their merchandise elsewhere, including their casket, flowers, or other merchandise, the funeral home does not benefit in the merchandising process and the family does. That would be a bailment for the sole benefit of the bailee. When a funeral home needs to store merchandise at another funeral home, then that would be a bailment for the sole benefit of the bailor. Also, when a funeral home borrows a coach or a family car from another funeral home, that would also be a bailment for the sole benefit of the bailee. Now we're going to talk about wills. There are 4 different types of wills. The first being simple wills and are most often used when the only thing that is needed is how to distribute simple assets from the estate to the beneficiaries. A testamentary trust will, which places a portion of your estate into a trust. Assets are distributed to the beneficiaries through the trustee who controls the assets. Joint wills are mostly used by spouses who have the intention on leaving their property to one another. Living wills provide very detailed instructions about the type of medical treatment or life-saving measures you want to be used if you become unable to communicate those wishes for yourself. There are also special types of wills which include holographic wills, nuncipative wills, and soldiers' and sailors' wills. Some limitations of a nuncipative will are only usually made during the testator's last illness. This type of will only applies to personal property at times. Only a limited value of personal property may be disposed of. A witness must frequently reduce the will to writing within a specified number of days, and they must agree on how the deceased disposed of the property. The lineal descendants of a descendant include the children and grandchildren. So if there were children living at the time of the intestate's death and there was no living spouse, the property would be distributed per capita, meaning equally to the children. If one child dies before the intestate and there are still living children, then that means the property would be divided into equal parts on the basis of how many children the intestate had. The deceased child's part would then be divided into 2 equal parts, and one of those parts going to each of the grandchildren. That then divides the property per stripes. The prime duties of an administrator are to preserve the estate and distribute it to the rightful parties. The prime duties of an administrator are the same as an executor, but there are 2 big differences when it comes to an administrator. In the appointment of an administrator, some states have a clear order of priorities, such as living spouse, children, parent, grandchildren, whatever that state allows. The second difference is that an administrator must in all cases execute a bond guaranteeing the faithful performance of the duties.